Ladies and gentlemen, it's an honor for us to be conducting this program this evening. Okay, I think it's important that you get to know who's speaking right now. Tamaina Tong Mungalo, she is currently our deputy chairperson at the Companies Tribunal. I think let's give her a round of applause.
Good evening, everyone, and thanks for coming. Next to me, I have the acting chief operations officer of the Companies Tribunal. We are excited you are here, and we hope to catch up with the time that we lost.
Thank you, Deputy. Okay, I'm sure if you open the folders that are on your desk, there should be a program inside. It will at least assist to see the proceedings for this evening. And we are hoping that we will try by all means to keep up with the time that we have lost a bit. And for those who will look for the bathrooms, as you go out, you turn to your right, they are right at the back. There will be refreshments afterwards. And yeah, we are hoping that you will learn one or two things out of this session. Thank you. And without wasting our time, I'm going to welcome Advocate Mahon SC. He is the one who will be doing the welcoming because we are being hosted here at the Johannesburg Society of Advocates. And maybe let me also acknowledge all the partnerships that we have. This evening, we've got the Advocates for Transformation. We've got the BLA. For my introduction will come as we move along. But let me just give a brief intro of Advocate Mahon. He is a senior counsel and a practicing member of the Mysel's group of advocates in Johannesburg. He is the current chairperson of the Johannesburg Society of Advocates and has served on the Bar Council on multiple occasions, contributing actively to professional governance and standards within the legal profession. He specializes in complex commercial litigation and arbitration with particular expertise in company law, construction and engineering disputes, business rescue, and insolvency. And in addition to his advocacy practice, he serves as an arbitrator, adjudicator in commercial and construction disputes and has been appointed as an acting of the High Court on numerous occasions. He is a member of the Chartered Institute of Arbitrators and the Association of Arbitrators Southern Africa. Ladies and gentlemen, join me as we welcome Advocate Mahon SC.
Thank you. Good evening, everyone, colleagues, distinguished guests, members of the tribunal, representatives of our partners and sister organizations, in particular NADAL, AFT, and the Black Lawyers Association, to all those present and to the members of the Johannesburg Society of Advocates. It's a pleasure to welcome you all to our chambers this evening. I should confess at the outset that when I first received the invitation to speak, I was tasked with addressing what I understood to be a rather formidable topic. I duly began preparing something suitably weighty and I hope insightful. But I have since been gently redirected to the more modest role of offering opening and welcoming remarks. I take some comfort in the fact that this allows me to retain a few fragments of that earlier preparation, while sparing you the full extent of it at this hour of the evening. It is a privilege for the Johannesburg Society of Advocates to host this seminar in collaboration, particularly with the Companies Tribunal and our valued partners, in particular Advocates for Transformation. We are particularly honored to do so at a time when the Tribunal's role is both expanding and deepening in ways that are of real significance to the legal profession and to the broader commercial community. May I begin by acknowledging Judge Dennis Davis, whose stewardship of the Tribunal continues to shape its intellectual and institutional direction. We are grateful for his presence this evening and for the leadership he brings to this important body. I also wish to acknowledge the program directors and organizers, and to thank all of you for making the time to attend. The theme of this evening's seminar, as reflected in the program, speaks to the strengthening of the tribunal, including through the appointment of retired judges. That development reflects a broader commitment to enhancing the quality, credibility, and the authority of the tribunal as a forum for the resolution of company law disputes. It's us, in turn, to reflect on the place of the tribunal within our legal system. As practitioners, we are often inclined to view the courts, natural and indeed default forum for the resolution of disputes. There is good reason for that. The courts occupy a central place in our constitutional order, and their authority is beyond question. But the reality is that not every dispute is best suited to the courts. The Companies Tribunal offers a forum which is, in many respects, tailored to the nature of the disputes it is called upon to resolve. It provides accessibility. It offers procedural flexibility. It allows for a degree of specialization, which is not always achievable in a generalist court. Where its jurisdiction permits, it has the capacity to resolve disputes more expeditiously and in many instances more cost-effectively. That is not to suggest that the tribunal stands in opposition to the courts, of course. Quite the contrary. It operates alongside them, forming part of a broader ecosystem of dispute resolution in which different institutions serve complementary roles. A well-functioning system is one in which those roles are understood and, importantly, both utilized. One of the challenges we face as legal practitioners, particularly in the field of company law, is precisely that of ensuring that justice remains both accessible and effective in the face of increasing complexity. That the subject matter we deal with is often intricate and the stakes are frequently very high, and the processes we employ can at times become burdensome, particularly for the common man. And in that context, the tribunal represents an alternative forum, but also an important instrument in advancing justice. It provides a mechanism through which disputes may be resolved in a manner that is both rigorous and responsive to the needs of those who come before it. Yet for all its potential, the tribunal will only fulfill its role to the extent that it is properly understood and engaged with by the profession. That is why gatherings such as these are so valuable. This seminar is, of course, an opportunity to raise awareness of the tribunal's extended mandate, including its capacity to arbitrate company disputes. But it is also something more than that. It is an opportunity for engagement. It creates a space in which practitioners and the tribunal can interact directly, exchange perspectives, and develop a shared understanding of how best to give effect to its mandate. There is also, I think, an opportunity for us to look forward and to consider how the relationship between the tribunal and the Joburg Bar in particular might be further developed. The bar is, at its core, a body of specialist advocates. Its members are trained to grapple with complexity, to distill issues and to assist adjudicative bodies in reaching just outcomes. There is considerable scope for that expertise to be deployed in support of the tribunal's work, whether through the appointment of members of the bar to panels, hint, hint, nudge, nudge, where appropriate, or through roles akin to pro forma prosecutors or other forms of structured participation. There is an opportunity to deepen collaboration in a way that benefits both institutions. That collaboration would, I suggest, enhance the quality of adjudication whilst also strengthening the tribunal's connection with the practicing profession. It would also serve another equally important purpose. The question of transformation within the legal profession remains a pressing one. It requires not only commitment in principle, but the creation of real opportunities in practice. It requires platforms through which practitioners can develop expertise, gain exposure, and participate meaningfully in the work of our legal institutions. What we must guard against, however, is the risk of entrenching a parallel legal system that fails to reflect the demographic realities of our society. Accordingly, in the exercise of all of its functions, the tribunal must remain a steadfast proponent of transformation within the commercial sector. And the tribunal, particularly in light of its evolving mandate, is well placed to contribute to that process by providing opportunities for participation and by fostering engagement with complex commercial matters. It can play a meaningful role in broadening access to specialized areas of practice. In this way, the collaboration between the tribunal and the bar has the potential not only to enhance the administration of justice, but also to contribute to the ongoing transformation project. As we move into the substantive portion of this evening's program, we will hear from speakers who bring a wealth of experience and insight. I would encourage all of us to engage actively with what is to be said, to ask questions, and to reflect on how we as practitioners can contribute to the continued development of the tribunal. Let me conclude by expressing the hope that this engagement will not be confined to this evening alone. The relationship between our institutions is one that can and should continue to grow. If this seminar serves as a catalyst for deeper collaboration, greater utilization of the tribunal, and a more integrated approach to the resolution of company law disputes, then it will have achieved something of lasting value. I thank you for your presence and for your commitment to the advancement of this project. You are most welcome. Thank you.
Thank you very much, SC, for such a warm welcome. You know, every one of us, when you visit a home anyway, you really want to be welcomed. So if you just walk in and the reflection on people's face, you know, are in such a manner that you can read in the lines, then it doesn't make you comfortable. So by saying this, I'm sure now we are all comfortable because we've seen the face is so welcoming. So feel free, relax. We are here to engage and interact as we get to know more about the Companies Tribunal. I think let's give him a round of applause. Thank you, thank you. The program of today, and now I'm going to call upon of the Companies Tribunal, our Judge Dennis Davis. But before he comes, I think let me just give a bit of a brief introduction so that you get to know him better. Judge Dennis Davis has got a BCom, LLB, and an LLM. He previously served as head of the Competition Appeal Court and the Tax Appeal Court. Between 1991 and 1997, he was the director of the Center for Applied Legal Studies at the University of Witwatersrand. He held joint appointments at VETS and UCT from 1995 to 1997. He was appointed a judge of the High Court in 1998 and as president of the Competition Appeal Court in 2000. Since his appointment to the bench, he has continued to teach constitutional law and tax law at UCT, where he is an honorary professor of law. Judge Davis is a member of the Commission of Inquiry into Tax Structure of South Africa and was a technical advisor to the Constitutional Assembly when negotiations for South Africa's interim and final constitutions were formulated and concluded. He hosted a television program, Future Imperfect, which was an award-winning current affairs program between 1993 and 1998. And I'm sure some of you, you've also seen him on a program on TV, Judge for Yourself. He has been a visiting lecturer or a professor at the universities of Cambridge, Florida, Toronto, and Harvard. He holds the following qualifications: BCom, LLB from the University of Cape Town, and an MPhil from the University of Cambridge. Ladies and gentlemen, let's welcome our chairperson, Judge Dennis Davis.
Thank you, Irene. Firstly, I'd like to thank Don for his kind remarks and for welcoming us here. I should tell you, the last time I was here, actually no, not the last time, the penultimate time that I was in this room was presiding over the Banks case, which of course has gone to the Constitutional Court, and probably they'll decide that long after, we reach 2050. But leave that aside. I want to tell you that looking at the audience I have here is so extraordinarily different to what confronted me on that particular day. I was saying to my colleagues here that Tembeka Nkatoibi was representing the Commission, and his side sat there. And other than that, there were, with a couple of exceptions, the overwhelming number of council were white men, and there were a couple of white women who spoke for the first time, because in 2019, when we had the first case, although there were some women juniors, not one of them was allowed to speak, not by us. And so, I wanted to say we've got a long way to go to actually ensure, as it were, an adequate transformation of the South African legal profession. And of course, the tribunal has to be part of that in some way, for the obvious reason that we are in the business of company law, which has traditionally been a white male preservative. To some extent, still is. And that's not right. And that shouldn't be. And so that's not to suggest, and let me make it absolutely clear, that I suggest that white men who've got ability shouldn't appear in front of them. They're most welcome. But the point that I'm simply making is, obviously our project is to have a legal profession in which cases generally are argued by the population, which reflects the population at large. I was a young judge. It was always noticeable to me that the only women counsel before me were ones who did matrimonial cases, right? As if they weren't good enough to do anything else. And that's the point I think I'm making. I want to start, if I may, with something that struck me as I was coming here, which is that the President had his 6th investment conference today. You might say, what on earth has that got to do with the Companies Tribunal? It's got to do with this. You cannot have development in a society on a sustained level unless you've got institutions that work. How do I know that? Because the 2024 Nobel Prize winners, Akemoglu et al., they were awarded the Nobel Prize precisely because they argued that the most central single feature of countries which have sustainable economic development is they've had institutions that work, that promote a level of efficiency, accountability, expedition of resolution, whether it be a national prosecuting authority, whether it be the South African Revenue Service, the South African Reserve Bank, or the judiciary, or any of the other institutions. If you've got institutions that don't work, you can't actually have kind of a successful in other words, people come to a conference and they'll promise all sorts of things, but nothing ever happens. And I mean, I can tell you right now, and I'm not going to go into that, the controversy of it all, but it's perfectly obvious to me that there's some institutions which are central to economic development in South Africa that are just not working. And so I regard the Companies Tribunal as an institution, not as a central one, but as one which we've got to take seriously, which we who are in fact beholden with developing it, to take seriously, because if we are going to have inclusive economic development, attract the kind of foreign investment which is going to increase GDP and ensure greater employment and ensure greater inclusive employment, you have to have institutions that work. Now, the Companies Tribunal was effectively set up for that purpose. It was modeled on the Competition Act, which, as you know, has a competition tribunal and a competition commission under that. And some of us who actually were privileged to be part of the drafting team of the Competition Act, landed up, myself particularly, in also being one of the drafters of the Companies Act of 2008. And to a considerable extent, myself and Professor Mongalo, and a drafter called Phil Knight actually drafted the Constitution. We were central to that process. And our idea was effectively, why should we not have a body which specializes in company law in exactly the same way as you have a body that specializes in competition law, which can act in parallel, not to override, not to essentially ensure that courts don't in fact do their business, which they must do, as I it's quite right. That is a central feature. But the bottom line of it is that why could you not have a companies tribunal which effectively provided an expeditious, cheap, and coherent way of actually dealing with companies' questions? Do you know, since I've been involved in writing one of the books on company law in South Africa, one of the most remarkable features about company law in South Africa is the fact that we have very few serious decisions on company law now. My colleague, Professor Blackman, who's the finest academic company lawyer that South Africa has ever had, and some of you may still use Blackman's commentary on company law when you have a problem. He once said to me that from the early 1960s onwards, the House of Lords stopped citing South African cases because as the apartheid government came in and they appointed a whole lot of judges who were commercially illiterate, the fact of the matter was that the jurisprudence declined. What's happened now is that the most nuanced company law is not available to any of us because it's done in arbitrations. And no one sees those, so we have no precedent. So we have a 2008 Act. And go and have a look at SAFLI. You will find far fewer cases than you'd expect. Far fewer development of the Companies Act of 2008 that one might have expected. Why? Because the matters go to arbitration. A friend of mine who works in one of the large firms of attorneys was just telling me the other day about an arbitration award which they received from a panel of three very experienced ex-appellate division judges. And he said to me, it's such a pity. The judgment is a really serious development of the law, and it's not available. So the point about the Companies Tribunal is that if we're going to actually use alternative dispute resolution, particularly in the area of arbitration, then it seems to me, even though if we do arbitrate on a case, it won't be binding on the next case, at least we can publish our arbitration awards, and that the legal community can then get the benefit of the reasoning that's been employed in those particular cases to guide you when you're advising your clients in the future. It's a scary business now, advising people in company law, because in many instances you're like in a rolled-in original position because there's nothing there. So the question arose as to, why in fact, number one, appoint retired judges, and number two, what ultimately is the purpose of the tribunal in the light thereof. Now, in relation to the first proposition, I'm going to talk about the amendment in a moment, but in relation to the first proposition, what I found when I took over the Companies Tribunal and went to the large commercial law firms, they sort of pulled their nose at me and said, well, we can go to the arbitration center and we'll get every fancy schmancy silk or retired judge. Who have you got to deal with these complicated matters? And all I could say was we've got a group of people who are appointed who are very talented, but it's true, don't have 25 years on the bench. And I can well understand why you would want, to have the comfort in a very complicated matter, to have someone who's been around the block a number of times. I have to tell you, and I'm more than happy to say this publicly, it took a devil of a time for me to persuade the minister that we should actually try to get some retired judges to supplement our panel. I asked for them for two reasons. Reason one was because I wanted to meet head-on the objections of these commercial law firms. And number two, I thought that for younger members of the tribunal with considerable ability but not great experience, to sit with somebody who'd been on the bench for 20 years was an incredible act of transformation because it's transferring skills. I can just say that from my own personal experience. When I first went onto the bench, I really didn't know very much. In fact, I should tell you that I remember when I was an acting judge and counsel kept on citing the Plaskon-Evans rule, I wondered why our court didn't need new paint. I knew absolutely nothing about what the bloody rule was about. What I'm trying to say was, I sat with judges of great experience who, number one, edited my judgments, and two, I watched the way they conducted proceedings, and that helped me enormously. So those were the two bases by which I sought to argue with the minister. Of course, my problem was that I got caught between ministers. So Minister Patel promised me that, yes, something would happen. It's like that old joke, well, not such old joke, now you can adapt it. The old joke is, I love you in the morning like I love you at night, or the checks in the post, or the most modern one is, definitely the Iranians want to settle. Donald Trump, the three great lies, right? But what I'm trying to say here, in all seriousness, is I found Patel sort of dilly-dallied, and then he left. And so now Minister Tao came in, and it took me another year and a half, so it's actually almost 3 years, to finally persuade them to take the matter to Cabinet. And I'm proud to say that they've now appointed the first set, and I want to make a comment in relation to what Advocate Mann said in a moment. So the first 5 that we appointed were judges Nafsa, Ponnen, and Mabar, all of whom were long-standing members of the Supreme Court, Judge Satchell and Judge Nugent, also on the Supreme Court of Appeal. Those are the first 5. All very experienced judges. It's going to be difficult for the commercial law firms to say, no, you can't have them, because I know they use them in the commercial arbitration. So the hypocrisy will now be exposed. I want to appoint, and when I met, Advocate Lawrence will remember, when we had a meeting, I think with the BLA, if I'm correct, and Advocates for Transformation, there were some of your members who asked me whether, in fact, I wouldn't consider actually asking them to be members of the tribunal. And it's right. Why not invite a series of particularly silks to be members of the tribunal? And I am trying. But it took me 3 years to get 5 judges. And you'll have to bear with me here. The Department of Trade and Industry sort of has got the speed of a snail when it comes to actually doing anything to help us. But on the agenda, and that's particularly important. And it's becoming particularly important, colleagues, for the fact that there is now an amendment to the Act, which I just want to get, Section 166 of the Companies Act, which basically says, if I can find it, here we are. Section 166 of the Companies Act has been amended to read, as an alternative to applying for relief to a court or filing a complaint with the Commission in terms of Part D, a person who would be entitled to apply for relief or file his complaint in terms of the Act or may refer a matter that could be the subject of such an application or complaint for resolution by mediation, conciliation, or arbitration. And now the only body that can do that is the Companies Tribunal, because what has been deleted is any accredited entity. So the private arbitration entities which have flourished in South Africa, when this particular provision, which has to be finally kicked into operation by the department, and I'm nagging that it should be any day, it means in essence this, that if you've got a case where the cause of action is sourced in the Companies Act, and you'd prefer to go to arbitration rather than to be subjected to the very lengthy court rolls, the only choice you've got once the Act comes into force is the tribunal. Right? You can't rush off to these private arbitration centers, which my own experience tells me cost an absolute arm and a leg, because I've done a few and I'm just astonished at what people charge for these. Retired judges, who I might add, are getting a fairly reasonable pension anyway, but that's another matter. Right? But what I'm saying, in effect, is that from now on in, right, so there's some that admit of obvious, clearly obvious referral to the Companies Tribunal in circumstances where your client or you have recommended to your client that refer to go to arbitration. And those, for example, those would be, the most obvious one would be disputes between directors. Obviously, when you're dealing with Section 72 et al. Of the Companies Act, manifestly, that's a dispute which is sourced only and completely within the Companies Act. And if you don't want to go to court, you can come to the tribunal for a resolution of that. So there then are some interesting questions. What about business rescue? Now, these are issues that are going to have to be explored, and your views on that would be interesting to me. Whether, in fact, you have a dispute with a business rescue practitioner or something in relation to business rescue, whether, if the Act now says that if you have a case sourced in the Companies Act, which business rescue is, why should you not be able then to go to the Companies Tribunal? And we all know that if you look at the law reports, year in and year out, the main issue where, in fact, cases are reported of company law is in business rescue. when I desperately look for coherent cases on directors' duties, fiduciary duties, corporate governance, you name it, not very much. Business rescue, the Encyclopedia Britannica is actually modest compared to the amount of judgments that there are in that regard. So the point I'm making is that this section, I am told, because I've been nagging like hell, it's gone, the President assigned it, by the way. Just the damn department that has just to put it into operation. But when it does, you can understand what I'm saying, that in fact that triggers a whole scope of activity for the Companies Tribunal where your method of resolving a dispute, the preferred method, is arbitration. It also strikes me, and I've been having conversations with the Deputy Chief Justice in this regard, that bearing in mind the effort to ensure that complex disputes now go to mediation before they actually proceed to trial if the mediation breaks down, that again here is a situation where the tribunal is mandated to do that. Arguably whether it's the only body who can do it, that's something we can debate. But again, it's there. And why is that there? Because it seems to me a sensible approach that if we are going to have alternative dispute resolution mechanisms, then why should we not have one that is basically a state-orientated entity, independent obviously, but which has the ability, one, to actually handle cases far more expeditiously than courts. And even if we do get a flood of cases, it's not going to be anywhere near the magnitude of what my poor colleagues suffer on a day-by-day basis in the high courts. That's one. Two, in principle, we don't charge. So we don't charge parties to come to us. I do think that if you get two big public companies who've got directors' disputes, it seems to me only correct that we should be thinking about what do we charge them for our service, simply because, why should they not pay something which would go to the cost of running an institution, which in turn is also helping small businesses and small entrepreneurs to resolve their problems. So then the fundamental question which has been put to me is, well, why should the Companies Tribunal have exclusive jurisdiction in this regard? What makes it so special? Nothing makes it so special. But there's a fundamental philosophical proposition which I'd like to advance. And the philosophical proposition I want to advance is that the Companies Act, which is an act of Parliament, provides a status to certain entities called companies and privileges those companies in a particular way. The whole idea of a corporate veil, the whole idea of a separate personality whereby the individuals in general terms can't be sued, that's a privilege which is granted by the state to an entity called the company. It's a policy consideration. Sure, no one's arguing that it shouldn't be there, but by virtue of the fact that it's the state that actually endows those entities with particular status, that it seems to me only proper that a state-orientated institution should have some role in the resolution of disputes of that particular kind. And that's why I'm arguing that the section 166 is going to be a very important one. Let me say this, I was not the architect of that amendment. I'm conscious of this because when the Competition Act was amended to take out the jurisdiction of the Supreme Court of Appeal from Competition Act, Judge Brunt said, well, what's happened is Dennis Davis was so tired of us overturning him that he got us out of the way. Well, of course, I'm not sure that was a good idea, given what the Constitutional Court does in competition matters, but that's another matter entirely. But I think it's only right and proper that we do have such an institution, and if we do have it, that it actually does its job. And its job, obviously, is not just large corporations. Its central focus should always be on assisting small entrepreneurs who have incorporated to resolve their problems without payment, expeditiously, in the most informal and convivial way in which it's possibly done. Sure, they should be able to have lawyers, and they do, but what I'm trying to say is there is a serious role here for encouraging small and medium-sized businesses which are central to economic development, and the Companies Tribunal can play, and does play, a significant role in that particular regard. So that's what we do. Let me make one final point. Many of you will obviously advise parties in company disputes, and I invite you to use our services. I invite you, at least give us a shot, right? Are you going to say, well, you know, why should my client take such a risk? Because I don't think it's a risk. And you can, and how would I know that? How can I prove that? Well, go and have a look at some of the reviews that the cases that we had. And of course, you've always got the one opportunity you all have with us is you can always take us and review to the High Court. You know, so it's not necessarily the end of the road. But I would ask you to use us, and I would ask those of you, particularly senior practitioners, attorneys and advocates, who really think, gee, I wouldn't mind making a contribution, right, to let me know, and I will push for as I am already, pushing for the fair round of people who may want to want to actually preside in the Companies Tribunal if you have an interest in this field. And that's why we're here tonight, to basically ask you to partner with us in ensuring that an institution set up under the 2008 Companies Act actually works for the population as a whole, works for the expedition of justice, and works to make justice as accessible for everybody. It seems to me quite scandalous that a small company where you've got a serious dispute has to wait forever to get to court and then pay enormous sums of money, right, in order to get in and to deal with it, whereas we have certain time limits. You come to us, and within a month, we promise you we'll give you the award. We'll deal with it expeditiously. So I'm here not only just to tell you about it, tell you what I think are very profound implications to of the amendment of Section 166, but also to explain to you why we think we have a role. And what is particularly important is that looking around the room, the more of you who participate therein, we can also be a wonderful forum for showing that commercial disputes should be argued and adjudicated upon by a far more diverse range of people than exists at present, which is, after all, a central project, which it must be, if the rule of law is to be preserved in South Africa. Thank you.
Another round of applause for our chairperson. Thank you so much, Judge Dennis Davis. I had an opportunity of knowing him as a supervisor also. And I remember the first time we had our meeting, it felt like I was in court. I had to have my story very clear. And at the beginning of our tenure, I saw the frustration, because as a judge, you are used to having people appearing in front of you to convince that your case makes sense. But then all of a sudden, he found himself having to convince the department that it's actually a good idea to have retired judges as part of our team. And well done, Judge. You really pushed hard to have that happening. And we are very well pleased. And thank you again for that insightful speech. And at this point in time, we are grateful that you have shared passionately about what you think the future of the tribunal should be and how the profession should engage with the Companies Tribunal. And at this time, that being said, we are hopeful that the panel paid attention to what the judge said. As we are coming to the next segment of our program, we are going to have this distinguished panel engaging on the topic and what has been shared by the judge. And I have the privilege of introducing them this evening. I will start with Mr. Motlohung. The difficulty of being a program director is the fear of getting the pronunciation of the names wrong. My maiden surname is Tong, ka Setswana ke Tong. But then when you introduce yourself to an African-speaking person, they hear Tong, and Tong is a tongue, right? And when you speak to an African from a township, Tong is what you use to curl your hair. So if I get it wrong, please pardon me. So I'll start with Mr. Machini Mutlong, and Ndate Mutlong is a chairperson of the National Associate of Democratic Lawyers. His legal career, he has been an admitted attorney since April 2001. He spent 20 years in different management roles at Legal Aid South Africa. In 2023, he started practicing on his own account under the name Machini Mutlong Incorporated. He has unquestionable commitment to social justice and human rights. He has litigated numerous high-profile cases. He is a sports and entertainment lawyer representing some of the leading professionals, footballers and artists. He has been involved in the legal fraternity and community outreach. As the current president of National Association of Democratic Lawyers and well known as NADEL, he's the vice president of the Law Society of South Africa. He has previously contributed in several roles, including panel member of the Free State Law Society Disciplinary Committee and SAFA Disciplinary Committee. He's the chairperson of the Legal Practice Council Free State, the chairperson of Belonomi Tertiary Hospital Board, the biggest hospital in Free State Province. He's dedicated to outreach program, including community legal education and advocacy. A round of applause to him. And for some people, they're saying it feels very, very uncomfortable as they are speaking about you, but I see they are used to it. Next, I will introduce Mr. Nkosana Mvundlela, right? He studied BA and LLB at the University of Venda, 1996 and 2001. I have a bad habit of calculating people's age, depending on when they did their first degree, so we will leave that for later. He served articles with Legal Aid South Africa Limpopo offices from 2002 to 2004. He got admitted as an attorney on the 13th of May, 2004, started practicing for his own account, trading as Mvundlela and Associate on the 6th of June, 2004, incorporated the firm in 2020 while expanding its operations. The firm currently employs 30 people, including 11 professionals as admitted attorneys. 2 of whom are associates and 1 a conveyancer and notary public. The firm deals with litigation, corporate governance, local government, supply chain process, management, construction and engineering law, and ADR. He has served the BLA in different roles in Limpopo, including being chairperson for 2 terms, served as the president of BLA now since 2024. A round of applause. Last but not least, I will be introducing Advocate Myron Durance, SC. He is a distinguished member. First, he is the advocate, he is a representative for the Advocate for Transformation advocates for transformation. He is a distinguished member of the South African Bar, recognized for his extensive expertise in commercial law, regulatory frameworks, and complex litigation. Having attained the rank of SC, he is acknowledged by both judiciary and his peers for his legal acumen, ethical standards, and consistent excellence in advocacy. He has LLB and completed legal training that laid foundation for his practice at the bar. And his career, which spans several years, he has built strong reputation for handling intricate matters involving corporate governance, competition law, administration law, and dispute resolution. And beyond the courtroom, he plays an active role in legal profession through mentorship, through leadership, contributing to the advancement of legal practice and transformation of the bar. Another round of applause. This panel was carefully selected to come engage on the topic. They can decide the order. They each have 10 minutes, and we all know what a risk it is to give lawyers an opportunity to talk. Time sometimes doesn't count. So 10 minutes each, ladies and gentlemen.
Greetings, colleagues. Let me first start by acknowledging the presence of the chairperson of the Companies Tribunal, Judge Davis. And let me also acknowledge the presence of my co-panelists, BLA President, AFT Chairperson, and distinguished guests, ladies and gentlemen. It's an honor for me to be in front of you, tackling a very important topic. I think my bio says it all in terms of my side of activism. I'm a social justice activist. So as we engage on this topic, what comes into my mind is the impact that the extension of jurisdiction of Companies Tribunal would have on members of the public, and also what impact will the appointments of retired judges have on the processes itself. Now, let me start with the extension of jurisdiction. And I'm going to tackle this through looking into whether or not those who are expected to benefit from these processes are fully aware of these very important changes into legislation. And these are just ordinary members of the public. We are all in concert that the Companies Tribunal plays a critical role in economic empowerment as well as transformation. Judge Davis put it quite clear without being euphemistic, and I applaud you for that this has been a terrain of white practitioners, big corporate entities, and it has created that lacuna in as far as participation of the small, medium enterprise is concerned. Now, this to me is a thorn, and it's actually an elephant in the room of the company's tribunal, because it creates a potential risk of dwindling case intake, and it would not necessarily serve those who are intended to benefit from. So the issue of stakeholder engagement comes to the fore. It's quite important that if you look into the annual report of the Companies Tribunal, for the longest of time, they've continuously talked to stakeholder engagement. But to what extent have they achieved dissemination of critical information to the public? I saw in one of the annual reports that the target is, for instance, to issue at least one, I don't know if it's still the case, issue at least one media statement per year, per month, so which will translate into 12 media statements per annum. Then you have, on the other hand, the community outreach, which at the time, I think it's just limited to 2 per year. And this, I'm saying under correction. But I'm looking at it from the angle of the impact that such engagement has to ordinary members of the public. So that's in my view, a very important part of or rather a challenge that Companies Tribunal need to take and ensure that they address that, which I believe is a gray area in the process. The second part that I would like to deal with, in as far as the processes are concerned, has to do with the efficiency of these processes. By nature, and in terms of the law, the decisions of Companies Tribunal are taken to be administrative decisions. Hence, these decisions cannot be appealed against. They can be reviewed. I think this would take us then to the next aspect of the my presentation, which is, why is it necessary for, or was it necessary to appoint retired judges? Can look at it from different angle. I think at some point there was a discussion as to whether or not there was skills audit to try and have a reliable and empirical data to make that call and that determination of whether or not there was that skills gap. There was a need, therefore, to reinforce that space through the appointment of retired judges. But one would also take it further, that in my view, appointment of retired judges brings about the credibility and integrity of the process. And I'll do some comparative analysis with regards to other processes such as or similar to Companies Tribunal. And you find it with, for instance, the Small Claims Court. For a very long time, I've been a critic of the model of Small Claims Court, that you have Small Claims Court which relies on appointment of commissioners who are not necessarily trained for the job at hand to adjudicate over matters that they preside on. And this talks to the credibility of that process. And I've been a proponent of proposing that there should at least be retired magistrates presiding over such matters or in such courts. Now, this goes to show that the steps that the Companies Tribunal has taken in roping in retired judges would go a long way in ensuring that we have the system to be really as credible as you would want it to be. But over and above that, you would have, because for the longest of time, if you look at the jurisprudence produced in the tribunal, there's been quite a number of conflicting orders, and it has been a concern. And what could have caused, or what could have been a contributory factor in having such conflicting orders? Could it be due to lack of skills, the requisite skills, the knowledge of those who are roped in to preside over matters? Could it be because much as you preside over a matter, you are independent, but at the same time, there should have been a sort of a baseline upon which you will be basing your decision. So that, in a way, will also come in handy to address that. I'm being distracted. Sorry, sorry, colleagues. I've been distracted. The timekeepers here are rushing me. Let me just conclude. What are the discussion points that we can perhaps look into as we engage on this? In my view, there are 4 discussion points that we should at least deal with. Firstly, how can the tribunal further improve access for micro enterprises? Secondly, what additional resources or training might be necessary for the tribunal members? And thirdly, should jurisdiction be expanded even further to cover more company law issues? And lastly, except the appointment of retired judges, is there a need for Companies Tribunal to look any further in terms of other legal professionals who should be considered for appointment to capacitate that bench? Those would be my contributions. Thank you very much, Program Director.
Thank you very much. Mine is more focused. President Machini was a very generous in his address. So for me, the starting point, or the proper starting point, is the institution, and that is the Companies Tribunal. So the issue is not whether the retired judges are capable, they clearly are. The issue is whether their appointment is consistent with and advances the statutory design of the tribunal. The tribunal operates within a structured dispute resolution system under the Companies Act 71 of 2008. Section 166 promotes accessible, flexible dispute resolution through conciliation, mediation, and arbitration. Section 193 establishes the Companies Tribunal as a specialized adjudicative body. It is not a court. So, in my view, the structure is deliberate. There's ADR, then there's a specialist tribunal, then court intervention when necessary. The Act begins with accessibility, not with formality. When one looks at one then turns to the jurisdiction, and in particular what the tribunal does not do. The design becomes clearer when one considers what the tribunal does not do. Matters requiring judicial scrutiny, or rather authorities such as business rescues under Chapter 6, fall within the jurisdiction of courts. Section 131 requires an application to the High Court. Those matters involves complex restructuring, competing interests, high-stakes decisions. The tribunal does not exercise that jurisdiction. The distinction is deliberate. It's a judicial power which is exercised by courts. The tribunal, in turn, promotes accessibility. There's a special tribunal, special adjudication, in which is then done by the tribunal. So the tribunal was not conceived as a surrogate of the High Court. It was designed to be accessible, efficient, and specialized. That design must be respected. Retired judges bring experience, decisional discipline, and institutional knowledge. As Judge Davis has observed, their appointment is often justified on the basis of skills and skills transfer. That is a legitimate consideration. Judicial retirement does not necessarily mark the end of judging, only a change in where it occurs. The question is, should every institution therefore become a court? The inquiry is not whether retired judges add value. The inquiry is whether their appointment advances the purpose of the tribunal. The tribunal is intended to be accessible, efficient, and specialized. The introduction of retired judges risks increasing formality, slowing processes, and undermining accessibility. Skill transfers require structured and intentional design. Without that, it is incidental, not systematic. The real question becomes, are we building institutional capacity or are we substituting it? Over-reliance on retired judges may displace emerging adjudicators, limit development, and slow transformation, and inadvertently become a retirement village. Over time, this creates dependency rather than capacity. Skills matter, no doubt, but institutional designs matter more. The question is not whether retired judges are capable. The question is whether their appointment aligns with the purpose of the tribunal. If they are to be appointed, it must be limited, structured, and purpose-driven. The Companies Act creates a layered system. ADR, Section 166, specialized adjudication, Section 193, and judicial intervention, such as Chapter 6, including Section 131. That structure reflects a deliberate legislative choice. If that design is not preserved, accessibility gives way to formality, and institutional development gives way to dependence. The issue is not whether retired judges have skills, it is whether their appointment strengthens the institution or quietly alters it. Thank you.
Emma, what do I say after you? You just made my life impossible. Good evening. Good evening, Judge Davis. I think that we, as society, are in the quest to substitute sometimes a reason for the decision by the mechanics with which we take the decision. And I think that can easily land us in a problem. The Companies Tribunal, Judge Davis, is not sitting with a problem of legitimacy. It is sitting with the problem of, one, inaccessibility, two, exposure to the entire world of the economy as it arises, and lastly, perhaps and brought the level at which our own people would participate. As matters stands now, everybody in South Africa can register a company. Every member of society can be a director of a company, whether you have knowledge of the kind of products you want to supply or not would not be the issue. But how many of them actually knows what it means to be a director in that company, and what are your responsibilities, and what alternative dispute resolution mechanisms exist in case there are disputes either between yourself or the competing interests that you have against another company or not. So from where I sit, contrary to you, Myron, I don't personally have a problem with a judge being appointed to go there, or the person is going to assist in the adjudication of a dispute. That judge at any rate runs a risk, if you read section 166, of somebody saying, I'm not going to allow you, after you conciliated the matter, to now come and arbitrate it. Because that's what your amended section 166 says in paragraph 3.9 of the agenda that you gave us. So imagine then you are taking that very Judge Nafsa, whose judgments are cited every day in courts by every other lawyer that you know, and then all of a sudden he's found in the tribunal and parties saying to him, recuse yourself. And remember the structures of all these bodies, just the way the CCMA functions. All the decisions in the CCMA are subject to review at the Labour Court. And then you are sitting with the Companies Tribunal coming in, and with a risk that you are taking these members of society, and I'm saying in quotes, because once you are appointed a judge, you are regarded as somebody that thinks just a little beyond common sense of Mr. Mvundlela along the street. And all of a sudden, Mr. Mvundlela comes and says, I think you should recuse yourself. You probably don't even have the technical knowledge of the kind of dispute we have because of the nature of the business we run. Then you have a problem. But because a judge is trained to actually discern issues, then you choose to trust him. Whether this will help you, Judge Davis, in attracting these big matters to come, I don't think it is correct to establish systems for big matters and for our preoccupation to be about whether big matters comes to the institution or not. I think the Companies Tribunal's primary purpose would have been to resolve issues of ordinary people, ordinary cases, and to what extent do we market the Companies Tribunal for it to be accessible, for it to be known by those people that it exists, and above all, to market it as an institution that has a turnaround time that is going to suit the kind of dispute that sits there. You would recall that in terms of the arbitration processes, there would be turnaround times where people tell you within the engineering space, we want quick decision making because in the engineering space we are constructing and we want our decisions made such that the project does not get delayed. And those are specific outcomes that they are looking at. That's why they have established the type of rules they have. How best do we assist the Companies Tribunal have that kind of mechanism that is going to assist the companies the dispute resolution amongst companies, intra and inter, the system in such a manner that it helps to resolve those disputes. And for a process that seeks to make sure the Companies Tribunal is extremely accessible, it is very easy for people to identify with it. I don't know to what extent are you having a footprint in every other sphere. Say, for instance, town by town. It is not for me who is the adjudicator. For me, it is who is the person who's supposed to access it. More than anything else, that is where I come from. You can't talk about access to justice when the people who seek that justice do not know you exist, or if they knew you exist, are not very sure of the processes that must be engaged in order to access you. So I come from that point that says, build a court. When you build a court, then make sure that those that have to access it knows of its existence. The Companies Tribunal is doing a good job. You probably making sure that the economic space becomes what it's supposed to be. But you are accessible to the few who have access to the kind of lawyers sitting in here. I mean, you're sitting with advocates right across the room. I doubt that there are attorneys here. If there are very few. I also doubt that they are ordinary members of the public, like me. So the point I'm making, it's easier. Who are you talking to? Are you able to disabuse yourself of the big offices? Then go to a village and get there and say, Peter and John have a company. Their company's job is to produce tomatoes. They are fighting about whether the tomatoes are ripe or not to be sold. That is the actual work that you, in my understanding, were established for. And I may use a vague example, but the whole point is, when you are not accessible to those that are in the space of the CIPC, and you are known by me and Machini and many others sitting here because we have clients that have these disputes, then for all intents and purposes, whether you say you don't even need lawyers to come to us, does not serve any purpose, because to a large extent the people who have come to you are people with lawyers. So that evaluation may become necessary for you. But whether you appoint judges on top, for me, Judge Davis, you will add value. You will probably get the kind of decision making that you may look for. Yes, it may slow down certain things if those judges are rule-based, so much rule-based that they are going to worry about their reputation first before they worry about the outcome. Because if they worry about their reputation first, then they are not going to railroad people. They're going to sit there and want to take time, listen to every story, irrespective of how irrelevant, and then you're going to have that challenge. But I think that we should be able to support your effort to strengthen the nature of decision making and also the value of the outcome that you would want to, at one point, be able to make it as a referral point. Because South Africa as it stands is a stare decisis type of legal system. Therefore, you are not going to have these decisions just made and then we move on as if they are not going to be referred to by any other tribunal that sits after that. So that will give you credence if your presiding officers comes that way. But take to heart what Myron says. Once you appoint judges, those that you trained outside of the judiciary may run a risk of being delegitimized because the parties that comes there may easily say, we would want our matter adjudicated by those that were judges because we think it's too complex. Then how do you deal with that? Because then it is going to affect the relations, inter and intra-relations of the very commissioners that you have who have to deal with those issues. So these are simple perception issues that you should be able to take to heart as you change and or add the kind of people that you want to appoint. Above all, you see, the legal landscape in South Africa is designed and developed within the context of where geographically are you practicing. I'm aware that 10 minutes is almost over. But believe you me, this is the point you need to take home. One of the reasons your challenges are sitting as they are, and then you're starting to think, is it because of the type of deciders that we have? It's purely because the economy of this country does not accommodate a rural economy. And when it doesn't accommodate a rural economy, you are then going to sit with transformation agenda that has a lot of pitfalls. Some of the judges, retired judges you are going to appoint, whether you like it or not, may have been judges in high courts where they may not have had any opportunity to deal with any case of particular scale, economic scale. And to that extent, you can't assume that because a person is a retired judge, then they must have this particular skill. It is wrong. There are judges who are not like you, Judge Dennis Davis, who don't know anything about SARS and tax law. They have never presided over that kind of a matter. You can't assume that they know because they are retired judges. So it is going to be important for you to say, how do you deal with skills audit against skills availability and against repurposing of that skill in order for you to achieve the purpose for which you want to appoint the skill for. Thank you very much.
You can do better than that. Thank you so much for such thoughtful contribution to the topic. Yeah, a lot to respond to reflect on. Before I open the floor for Q&A, I'm going to give the judge to have a few comments, and in the meantime, while he's talking, prepare your questions. Then we'll take it from there.
Yeah, but because I don't think we're presenting ourselves as well as we should. Let me give you an example of what I mean. We have spent an incredible amount of time dealing precisely with what you're talking about, small communities. So we've been on radio stations. We've been on community radio stations. We go to conferences. We basically try as best we can to be, and you'll be able to explain this, but we literally are out there all the time talking not to the large firms. We're talking to ordinary people through, I mean, the amount of interviews that I've given, the amount of talks that I've given to admittedly, they may not be in the rural community in talks, but they certainly in relation to community radio stations, etc. We try very hard to actually get to them as best we can. Are we doing enough? No, of course we're not doing enough. I agree. And part of the reason is the point that you make, which is the structural nature of the South African economy, which I'm sorry, I'm not prepared to take blame for, but I'm with you. No, I know you're not. And I'm only being, no, I know you're not. But you're totally correct. But we do. In fact, I would say that almost 90% of the marketing and advertising we do, not to large firms, not to large corporations, to nobody else other than ordinary people, because they are a central focus of our mandate, and we must keep to that. But let me make a second point. I did not cause the Act to be changed. The Act was changed by a recommendation clearly through the Standing Committee on Company Law. I'm not running away from it. But it means, whether you like it or not, that we now the only we are the only group that can arbitrate company law disputes. So it's all very well telling me, I shouldn't get retired judges in for that. But here's the thing. The way it works is I will allocate. Number one, let me make this point. To get any retired judge was an unbelievable effort because we pay peanuts in relation to the amount of work that people do. This is not 40, 50, 60,000 rands a day stuff. If somebody's going to get 7,500 rand a day, that's a lot of money. So they weren't queuing up to do this. What I persuaded them to do was to say, I don't need you for all the cases, absolutely not. But I'd like to allocate one judge with 2 other commissioners to deal with complex arbitrations. I'm not going to sit there with a full bench of 3 judges. And frankly, if the large law firms don't like it, that's their problem. They don't want to arbitrate. Let them go to court. That's fine with me. But the point was never, ever that the tribunal will be dominated by judges. Not in the slightest. But it seemed to me absolutely logical, right, that if we were going to have, which is not our calling, if we've been told that's part of our mandate, if we're going to deal with complex cases, well then, to be perfectly honest with you, we've got to have the people to do that, which is why I'm reaching out to all of you to actually, put your money where your mouth is and come and actually be a tribunal member and take 1 or 2 cases a year. Right? I'd be delighted to have any of you. And I've got a list of people already. You'd be quite surprised who's on that list. I'm trying to press the minister. If the minister would say that today, I would welcome them all. Let me make another point. You'd be surprised that the vast majority of cases that we here have no lawyers. I can't think of one arbitration that I've done in the last 2 years. I can think of 2 where there were very junior attorneys, and in the main, they're people representing themselves. And they're small disputes coming from all over the country, and they come to us. So this is not a question that our customers arrive with a battery of senior, junior counsel, and senior attorneys and clerks, etc. Not at all. So what I'm trying to say is this is not a binary. What I'm arguing is our mandate must be to ensure that the point that you make, the 2 people who set up a company, in Shoshangulu and selling tomatoes, right? Of course they should be able to come to us. And the more we're able to reach them, through whatever means it is, and we're trying really hard. The amount of Saturdays that I've spent talking to strange groups of people that I would never have spoken to in my life before to try to explain them is it's because we've got really good people running our marketing thing because they understand that. Let me make another point. Part of my job is also to expand our mandate. If you look at the cases we do, right, we were roughly running at 350 cases a year. That's not enough to justify the institution, right? Because it costs a lot of money. So one, we want to expand that because a lot of our work is name disputes. Mr. A sets up a company, then his name or her name is the same as some public. And then there's a whole, Adams and Adams come running to change that. And most of those are unopposed, despite all our efforts to actually inform the party accordingly. We then we get a whole range of stuff about the exemptions of the Social and Economic Committee, which is part of the Companies Act. And we get far too few disputes of the kind that you're talking about or that I want to hear. I'm more than happy to do the arbitrations, which I quite enjoy, of small, of people really, small companies where they're having disputes. And our campaign is to reach out as best we can. The retired judges are there because having been faced with the problem that I could get complex cases, I needed to buy in some additional expertise. But let me give you this assurance. There will be no arbitration if we have 3 arbitrators where more than one of them will be a retired judge, because it would be wrong to do that, right? Which is why I'm inviting all of you as well, and anybody, and other groups that I'm looking for to be there. But my campaign, if you wish, right, you are just part of the broad marketing campaign. Reach out to you. But if you think that, this is our exclusive focus, it isn't. Our major focus is persuading those who need cheap, accessible, and quick resolution of their disputes to come to us. I inherited an institution which was hardly doing that. That's our main focus. That in the meanwhile, in between while, we've now got to deal with all forms of arbitration. Well, that's just what the statute has given us, and we've got to deal with that as well. But if you said to me, in a year's time, and I'm sorry for taking so long, because I think all of you have made such important points that, and of course it means we've got to do much more work, and I'm inspired by what all of you have said to do precisely that. But let me say this. If you come to a year or two's time and say, Dennis, what do you regard as your achievement for the Companies Tribunal? Is if those small companies have come to us in rather greater numbers, I'd say we've done our job. And that is our focus. And we will continue focusing on trying to get more of them on board. But please don't be confused by the judges. The judges are there because having been faced with the fact that we could be the only group who now is going to arbitrate complex disputes, and let's be honest about it, you can tell me what you like, but people are choosing arbitration in the courts for obvious reasons, because it takes so bloody long to get into a court. If you've got a 2 or 3 year delay in a court case, you're going to try to arbitrate it. Everybody does. So if you're going to have those cases, we will do them, but I want to tell you that part of the object of the exercise will be if you have a judge like Judge Nafsa, who's on the Supreme Court of Appeal for over 20 years, and by the way, does know about many of these things because his background was he worked at the Legal Resources Center and other public law institutions. Take someone like him, you have him with 2 other members drawn from different experiences, you get a much more diversified bench than you're going to get on the bench. And that's my aim. And so thank you to all of you. I hope I'm not sounding defensive, because what I really wanted to say was that to a large degree what you've said is we've got to do a hell lot more work in precisely all the directions that all 3 of you have urged us to do, and we will try our best.
Thank you, Judge. We have a roaming microphone. Does anyone have comment or a question for the panel or the judge? Okay.
Thank you. Can I go ahead? Yes, now I think it's working. Yeah, my name is Tepo, and I would like to comment and maybe even pose a question on the basis of the presentation made by Professor Davis and also the practitioners. The question relating to the purpose of the Companies Tribunal being made specifically for quick decision-making, accessibility, and for small and medium-sized enterprises is true, but the intention had always been that it should be able to then make decisions that can actually stand up and be comparable to those of the courts. However, what stands in the way is the issue of the fact that they are a creature of the tribunal is a creature of statute. Now, being a creature of statute does not mean that, as opposed to the High Court, which has got inherent powers to adjudicate on the matters, that means that the Companies Tribunal is of a lesser value in relation to the matters it can decide. Being a creature of statute means that if the statute has actually afforded an opportunity to the tribunal to address a matter that would ordinarily be heard by the court, then that is the matter that it should actually deal with. And I think if Section 166 gives the tribunal a matter that should ordinarily be seen to be a matter that belongs in the High Court, that is what the statute actually expects, that it should be done in the tribunal, and therefore we cannot try to say, but that is a matter that should be reserved to the High Court, because the statute found it appropriate that it should be done that way. Many people have argued that being a creature of statute, basically means that you cannot deal with matters the same way as you would with the High Court that has got inherent powers. But I argue that being a creature of statute also means that if there are matters that are given to you that are greater than what a normal tribunal would get, therefore that is what you deal with because it's in terms of the statute. Thank you very much.
I guess that was more of a comment. You want to reflect? Okay.
I don't think the perception that you should hold of the comments that we made is such that 166 gives exclusive jurisdiction to the extent that you can't do 1, 2, 3. The whole point from where I think I understood the comment is that indeed 166 does expand, and then it creates an opportunity for arbitration. And we know that any arbitration depends entirely then on what do you do beyond that arbitration, what do you do with the award. And as a result, the Companies Tribunal would be doing its job if it does preside over that matter and gives a quicker solution to it. I gave an example of the engineering sector, where you definitely have engineering contracts that are structurally within the contract itself, provides for ADR mechanisms that says to you, once you raise this type of a dispute, a person is going to adjudicate it before you even go to arbitration. That order binds you until you get to arbitration, so that the construction does not get to be delayed simply by one difference at a corner. Now, that is another element that the Companies Tribunal would bring to bear if that becomes part of the work that the tribunal does, because then it will help expand the alternative dispute resolution mechanisms in the country to facilitate the economy, because it is at the center of the economy that the Companies Tribunal must find its relevance, not outside of that mandate. Thank you.
Thank you. Another comment, question? Okay. Dr. Koza?
Thank you so much. I just think I should actually respond to the issue of going to villages. I think this is actually very important for us as the Companies Tribunal, in that we have honestly identified the need to go to different parts of the country, meaning that we do our best in terms of ensuring that whether you are in Rimfastmark in the Northern Cape, Komati Port in Mpumalanga or Musina, we try our best to reach you because we want to make sure that this service, which is a public service, is readily available. And just to confirm what the chairperson has said, we also push very hard. We're limited by resources, unfortunately, also to go to radio to make sure that we amplify the message of utilizing the service of the Companies Tribunal. This is really very important for us. Thank you.
Thank you so much. We have another question or comment.
Good evening, everyone. My name is Robin. I'm a litigation and dispute resolution attorney. So obviously, by the time matters get to me with respect to contractual disputes, alternative dispute resolution mechanisms are already built into the contracts. So the contracts will already make provision for us to refer the matter to arbitration. One of those considerations for parties is privacy and confidentiality, which is why we end up in arbitrations, because they don't want those awards to be made public. That's one comment. The other thing I'm taking away is that for my colleagues within my firm who work in the corporate commercial division is responsible for drafting contracts, is the consideration of whether or not we don't build into our contracts upon the advice to our clients that matters be referred to the company tribunal for resolution, in the same way that it's now become trendy, so to speak, to first build in dispute resolution mechanisms like mediation first before it goes to arbitration. So it may be a consideration for, as attorneys, when we go out and give advice to our clients and we draft contracts relative to company law disputes, is that we consider putting into our contracts that there is an option for alternative dispute resolution for a direct referral to the Companies Tribunal rather than mediation or arbitration, or as an alternative to both of those. Thank you.
Thank you so much for that comment. Okay.
I have not had the opportunity to go through the MOI that is on the CIPC website. All of you sitting here may be aware that a lot of our people are actually registering companies, either getting shelf companies and all those things, and then they are given that standardized MOI. It just struck me now to wonder as to whether in that MOI, is that not opportune now to look at that to assist those people to actually get to that kind of environment? Because as it stands, it may be an MOI as it is, standard, it doesn't have all these options that we are talking to, and you are correct, my sister, to the extent that I remember. Too often we don't advise our clients about these things because our clients comes with these contracts having been already established, and with them now having work obtained from third parties. And in terms of the SLAs that they have entered into with those third parties, they already provide for a particular dispute resolution mechanism. But I think it assists us to also refer them then to that tribunal in the same environment of arbitration, because then at least 166 gives you an opportunity to go to arbitration with the Companies Tribunal, not necessarily with the Arbitration Society of South Africa or whoever else. So that becomes just another angle, and it becomes cheaper because AFSA will charge you for whatever that you are bringing there, whereas the Companies Tribunal does it probably for far less, if not for free. So that opens the door. But I wanted just to refer us to the possibility of the conversation, my brother, with the CIPC registry about amending that MOI, standard MOI that they have, to talk to these kind of issues about dispute resolution to the extent that they can be referred to the tribunal, because without that clause, those people end up not knowing that they can go to this body and not go to the other body. Thanks.
Just to respond to the Prof. One looks at the labor laws arena or sphere. So it's settled law that where a statute provides a specialized dispute resolution process, that the jurisdiction may not be usurped. So I don't think you run the risk of being irrelevant. There's a long line of cases from the Constitutional Court all the way down to the Supreme Court of Appeal that recognizes the jurisdiction of specialized remedies created by statute. Thanks.
Thank you so much. Another comment, question? You.
Yeah, I mean, I think that just apropos the 2 points made, I think you're quite right. I hadn't thought about the MOI point, but it's a really powerful point that, you know, even your rural person who incorporates the company, if it's formally incorporated, there's an MOI of some sort. And whoever's advising would be well advised to say, you know, there's a way of resolving your disputes and having a clause within the MOI, which I think is what you're suggesting, as I understand, which I think is a really fine idea. But what I also wanted to say was, of course it's true that when you go to arbitration in the ordinary course, the entire thing is private. Now, given the statute, matter comes before the Companies Tribunal. Of course, we do publish our decisions. Now, we need to understand in any event that arbitrations are voluntary. You know, which is no one forces you to do it. If you want to, you can. And it may mean that we're going to have to approach certain form, you know, almost making, both for small and large sort of arbitrations, to say to people, we do publish this, but we can publish it in the way that, for example, the Special Income Tax Court decisions are published, where no names are given of any kind. And often it's very difficult to know who the parties are. So we may have to take that into account. But at the end of the day, it's a voluntary process, and people make up their choice. If they don't want to go there, they can go to court.
Thank you so much. I believe that we have covered everybody that had questions, and I would like to extend my sincere gratitude to our esteemed panel. Another round of applause to them, please. And indeed, they have engaged and they have given us a lot to think about. And I don't want to take the job of Dr. Koza, our head of marketing, to come and thank you, everybody. And my job ends here, and you've been a wonderful audience. Thank you.
Program directors, Ms. Matato, Dr. Tong Mungalo, chairperson of the Companies Tribunal, distinguished panelists, our partners, the Johannesburg Society of Advocates, Advocates for Transformation, Black Lawyers Association, as well as NADEL. We thank you and we're saying good evening. So it is my distinct honor and privilege to deliver a vote of thanks at the close of what has been a truly insightful and impactful seminar. We are expressing appreciation really to Judge Dennis Davis, whose thought-provoking address has not only enriched our understanding, but has also reinforced the critical importance of strengthening adjudication within the Companies Tribunal. To our valued partners, the Johannesburg Society of Advocates, as represented by Advocate Mehon, Senior Counsel, we also express our appreciation. We are aware that he left due to family commitment. We appreciate the warm welcome and the gracious hospitality. And to our panelists, we just want to take a moment and thank each one of them. From my left, Mr. Mvundlela from the BLA, in the middle, Advocate Joran, Senior Counsel from Advocates for Transformation, and Mr. Machini Mutlawung from NADEL. So your perspectives as panelists has added a lot of depth, balance, and practical insight into this particular discussion. We are equally grateful to each one of you. To all our delegates, we thank you for your presence, your engagement, and thoughtful contributions. Your participation is what gives this engagement or session meaning and value. I would like to acknowledge our chairperson of REMCO, Ausdineo. I have not seen members of tribunal, but I've seen other people that I can actually highlight. Prof. Okay, and the chair of ARCISI, I'm sorry I was not aware. And thank you so much. And I see we've got Prof. Marumahaye, who's, if I'm not mistaken, a former member of the tribunal. And we also have Prof. Mwepe from UJ. We also appreciate, I'm not gonna single out everyone, but we appreciate your presence. And finally, I would like to acknowledge all staff of the Companies Tribunal, particularly the communications and marketing team, and those that are working behind the scene. Your hard work and coordination and attention to detail has ensured that this becomes a success. As we conclude, may the insights shared here today not only end in this room, but continue to inform further engagements, and we hope to take this session again to other provinces so that we can be able to maximize engagements. And lastly, I would like to say on behalf of the Companies Tribunal, thank you all for your presence and contributions. Please join us for dinner and continue to network. Thank you very much.